of John Marshall, who started the whole process of federal Indian law, federal colonial law. His father was actually in charge of giving out some of the land for the to pay off the Revolutionary War soldiers, and so that was part of it. And so after that, they had the Treaty of Stanwix in 1784. This was not a very good treaty, but it was with the Haudenosaunee. The main thing is that it recognized the Haudenosaunee as a separate people. Apologize for this. I've got to. There we go. All right. But it took a lot of land. So right after this treaty, they had what was called the Northwest Ordinance, and in this one, this dealt with this area over here between the Ohio and Missouri rivers. And what that was trying to do was to open up the land so that they could pay off the soldiers. And it paved the way for what we call the Manifest Destiny of the Western Expansion. There we go. And so, so the United States was very concerned about the state of New York and other people taking Indian land. The United States wanted to have total control over it, right? And that was because they needed those resources. It was a power grab. And so you'll find in our Constitution what they call the Indian Commerce Clause, and they put in the Indian Commerce Clause that only the federal government can deal with the Indians, right, for commerce, and that includes transferring land. So if you're going to get land from a tribe, it has to be with federal approval, and you'll find that in the U.S. Constitution. Interesting thing about this: who said that? The Pope said that in 1493. After Christopher Columbus came over here and discovered America, he discovered America. The Pope issued a papal bull called the Inter Sierra of 1493, in which he said the first Christian nation that discovers a land shall have exclusive authority to deal with the indigenous people that are there, to take their property or whatever. And so you'll find that repeated again. It's a common theme that's repeated over and over again. Repeated in the Constitution of 1783. And then in the famous case, this is the one that started federal Indian law, Johnson v. McIntosh in 1823. So we're talking about 50 years later. In Johnson v. McIntosh, right, that involved two people who got property down from India that was formerly Indian land. One got it from somebody who got it directly from the tribe. The other one got it through the federal government. And so the issue was they're claiming the same land, although it's manufactured. It's a manufactured case. They weren't really claiming the same land. They pretended they were because they wanted this issue. They needed to settle the land title so that they gave away the land to non-native people. And so the way they settled the land title there, they said, well, the person that got their land through private parties, your title's bad because you didn't get through the federal approval. The people that got it through the federal government, you got good title. And so that was a Johnson v. McIntosh case. So one of the early, so it's this whole claim of exclusive federal authority. There we go. And then after that, they had the Buffalo Creek Treaty of 1788, which is a fraudulent treaty. They didn't get enough signatures. So the people that signed it, they plied them with alcohol. They were drunk. It's very famous, but they stole 2.5 million acres here, and it was negotiated by a private person. So you have this situation. This is what I'm talking about. You have a private person acquiring 2.5 million acres of New York land, right, directly from the native people, and then that's later been held to be invalid. But the Senecas lost a lot of their land, and that's the Onondagas were reduced to this size. Another illegal taking, 1782 by New York State. Just took it. Let's see here. I apologize. I'm not used to having these problems. There we go. And so then after that, they had what are known as the Indian Commerce Act. Indian, it's called the Trade and Commerce Intercourse Act. It's known as the Indian Intercourse Act. It started in 1790. There were 4 or 5 of them. I think they went from 1790 to 1843. And what they did in these, again, they're saying the federal government's the only one that can deal with native people, the only one that can have commerce. And so they forbid states or private parties from taking land from Native people without federal government permission. Then they entered into the Canada Treaty of 1794, and here's another wampum belt. Native people, they had a written record, but they kept it in beads, and they had a wampum belt. These are the 13 colonies you see surrounded here. And the one on the right, down by the house, that's George Washington. And the one on the left is Tadodaha, who's the head of the Onondaga people. And so they're making this treaty of 1794, and in that treaty, the United States recognized the territory of the Haudenosaunee. They restored some of the Seneca land here that was taken, was restored to the Seneca people in recognition that it was illegally taken. And so you have all these protections then of native land. So here's what happened for the Onondagas. You can see those dotted purple lines. That was their original territory. After all these takings, then they're down to here. They went from 2.6 million acres to 7,300 acres, all without approval of the federal government. So it's all illegal takings. So what do? You see the Cayugas and the Oneidas. The Oneidas were actually pushed out. They settled in Wisconsin. Cayugas were, some of them were sent down to Oklahoma, and so forth. They were, and you'll see the Akwesasne up here. This is the Mohawk area up there on the Canadian border. They were real prominent during the 1970s. On top of that, the sacred lake of the Onondagas, which is in Syracuse, was contaminated by the industrial development, salt with salt and mercury and other things, potash, and over hundreds of years. And it's now one of the most polluted, it's probably the most polluted lake in the United States. It's right there in the center of Syracuse. They've got a mega shopping mall, kind of like what they have over here, right there next to the lake on contaminated ground. They can't fish, the fish are all gone, destroyed, and this was their sacred lake. This is what the invaders did to their lake. So Honeywell was the last big developed that area. They recently were able to get 1,000 acres of that land returned to the Onondagas. So that's the Onondaga territory there in this area. Well, what do we do about this? So they sued, of course. Most Native people go to federal court. What you don't realize, though, federal courts are the courts of the colonizer. These are not federal, these are not courts of the Native people. These are not their courts. They're the courts of the colonizer. So you're going to the colonizer, and when you sue in federal court or state court, you're going on your hands and knees and begging for relief, right? And that's what's happened for over 200 years. Now, the first problem that they had was that the federal courts didn't recognize Indian people. Until probably the 20th century, no Indian person could testify against a white person. It was not allowed in court, right? Native people weren't allowed to vote until the 1950s for a lot of people. Citizenship was supposedly granted in 1924, but the Onondagas refused citizenship. They are not citizens of the United States. And so there was no real legal remedy available for the return of the land. They did set up the Indian Court of Claims in the 1940s, 30s, and 40s, which allowed some claims, but you could only get money. You couldn't get your land back. So where's your remedy? You have what we call an adequate remedy. And just so you know, kind of know where we're going, there's a human right to an adequate remedy, or an effective remedy, right? And so if you're not given a remedy in court, where there's a wrong, there has to be a remedy. A wrong is taking of your land. If you're not given a remedy that allows you to get your land back, somebody steals your car, you have a right to get your car back. If you don't have a remedy, right, for that wrong, it's an inadequate remedy, ineffective remedy. That's a violation of human rights. That alone is a violation of human rights. And so for Native people, that's been a lot of what's happened. Colonialism and colonial domination has denied the remedy. First off, they said that Native people weren't people, they were savages. Right? Black people weren't people, they were savages. That's the Dred Scott case. They were property. They weren't even savages, they were chattel property. Right? We have another case called the Standing Bear case, where they had to decide whether or not a Native person was a human being. What that case said, well, if you've left your tribe and become white, you're a human being. If you haven't left your tribe, you stayed Indian, you're not a human being. So they killed Standing Bear was the chief. They killed his brother, Big Snake, because he refused to change his way and he tried to leave the reservation. They killed him. Reservations back then were prisons. If you left the reservation, you get shot. And so, anyway, finally in 1974, the U.S. Supreme Court recognized in the Oneida litigation, they recognized that the Trade and Intercourse Act prevented the sale of property, and therefore it was wrong, and that Native people could state a claim in court. So the first time you could actually have a remedy for something that was done 200 years ago was in 1974. And so then they started a law process. There's about a dozen cases that came up. So after they did that, then they had a bunch of litigation on this, and they went through, and finally in 2005, they had this case, the U.S. Supreme Court called Sherrill versus Oneida Nation. It's the city of Sherrill, but that's decided by our wonderful Ruth Bader Ginsburg, who was probably the most progressive justice besides Thurgood Marshall, to sit on the U.S. Supreme Court. And she recognized the doctrine of discovery in her decision, said that it was not Indian land, that the land that they were claiming, the government could do whatever they wanted, right? And then she pulled up what she called the rule of equity. And rule of equity says, well, it's happened for so long, it's been 200 years, you've got all these people living on the land, so justice kind of demands that we overlook this theft, gross theft, human rights violations. We overlook it. We're going to rule in favor against the tribe and in favor of all the invaders that were occupying their land. And so that was the end of the ball game there. Right? It was inequitable to kick all the white people off, even though they didn't belong there to begin with. So what do? You're stuck. 2005. You got these 5 or 6 nations of the Haudenosaunee, don't know where to go. So it's about that time that they had, all of this, and I'll go through this pretty quickly, but John Marshall was the one that created federal Indian law, and that's what they were applying here in 1823. He created the 3 fundamental doctrines. First one, doctrine of discovery, which says that for the nation that discovers the land, they're the ones that have title to the land. In other words, Native people don't have title to the land. They can't own it because they're savages, number 1. They can't own it because they're Christians, because they're not Christians, number 2, right? And they can't own it because they don't take it. They don't exploit it. And they don't put fences around it, right? And therefore they're violating the command of God when he kicked Adam out of the Garden of Eden and said, you will toil the earth. So if you don't toil the earth, you have no right to the earth. They actually say this in their decisions of John Marshall in 1823. Yeah, you had a question or comment?
Well, statement. When you're talking about remedies, right? I just brainstorm a lot. You're having different remedies for different tribes, right? Because I mean, when you're talking about remedies, what do they want? You know what I'm saying?
Right. Yeah.
The original, indigenous people, and or tribes, right? So they're gonna want that remedy. But what is that remedy for that tribe, for those people?
Right. Well, the issue there is not that there aren't some remedies, because they were giving out money. Like they offered millions of dollars for the Black Hills, but the people wanted the land back, so they refused that money. It's sitting there, right? But other tribes have actually taken the money instead of taking that. So you do have different remedies.
It comes to my mind, and why it was a statement in the form of a question, I guess.
Yeah, and I'll get to that in a minute, because I actually cover that here. So then the other doctrine they had was called the trust doctrine, and the trust doctrine says because you're a savage, you're incompetent. You can't take care of your own resources. Therefore, we're going to take care for you. So we're going to be the guardian, right? And so they have this guardian-ward relationship that you're incompetent. And that actually started from the beginning of colonialism, but it's part of our federal Indian law. And therefore, Native people don't actually own their land. They're held in trust by the federal government, right? They don't own their resources. They're held and managed by the federal government. That's why we had the Bureau of Indian Affairs. Because Native people, even today, are savage, incompetent wards of the state. Right? So, and then because they're the guardian, some people say this comes out of the Indian Commerce Clause. I don't agree. The plenary power doctrine, which means absolute power over native nations, right? That's what plenary means, is absolute power, right? That absolute power, I think, comes from the trust doctrine. There's a Supreme Court case on this as well. But it says because you're the guardian and you have an incompetent ward, you make all the decisions for that guardian as to what happens in their lives. And that's that plenary power. But anyway, you'll see that. So you can't really question that. It perverted international things, and so that human beings became less human. This doctrine of theft, doctrine of discovery, and so forth. They were not only racist, but they were politically done. So, and you'll see it's the law today. In the recent case of McGirt, where the U.S. Supreme Court ruled that the Creek Nation was still alive, that the territory was still there, and because Congress had not ended it, they had not taken it expressly. We have a rule in federal Indian law that says that the federal government is going to take native territory, they have to do it expressly and unequivocally, right? And so they say, well, they kind of did it, but they destroyed their reservation by taking all their land. They destroyed their government, replaced it with the Western government. They destroyed their courts, replaced it with the Western court. They destroyed their culture, the language, taken everything from them, but they never said we're taking your territory. They actually say this in that decision, right? So they committed ethnocide and genocide, but yet they never really took the territory. So the city of Tulsa now is in Creek territory, they said. But at the very last sentence of this decision, and this is what most Native people love this decision, and they say, oh yeah, this is great, Supreme Court's on our side. But the very last line of Justice Gorsuch, who wrote this decision, he says, but Congress can take that territory anytime they want to. They just haven't. So he sends up a red flag. And so that's the plenary power doctrine, which is recognized here. And then the Indian Child Welfare Act, what was that based on? That was based on the plenary power doctrine. They didn't say that Native people get to keep their children because they're sovereign nations and because of their culture and human rights. In this decision, written by Amy Cohen Bryant, who has 2 Haitian children that she's adopted, right, stolen. But they in this decision by her, she says that the reason why the state can't adopt out the children and why the Indian Child Welfare Act will be supported is because the federal government controls Native people. The states don't. So it goes back to the state versus federal control of Native people. And so the plenary power, the total absolute power of the federal government over Indian people excludes the state. So the state can't come in and take Indian children. That's what that decision says. Everyone says, oh, it's a great decision because it upheld the Indian Child Welfare Act. It actually is a horrible decision because it said it because of plenary power doctrine, not because they were sovereign people that need to have their rights respected. On top of that, she reserved the question about whether or not it's a racial discrimination to give Indians special protection. And what she did is she left the door open. You'll find this, I'll predict that within the next 10 years, there'll be a couple more cases that will come up. They've got one on casinos right now that says you're discriminating against white people, white discrimination, white supremacy. You're discriminating against white people because they can't have casinos on their land, but Indian people can have casinos on their land. That's white discrimination, right? One of those cases almost made it a few years ago up here. There's another one that's way right now. They're saying the same, they made that same argument in this case, in the Brackeen case. They said, you're discriminating against white people saying that they cannot adopt Indian children. How come Indian families can adopt Indian children, but white people can't adopt Indian children? It's racial discrimination. And it is. It is racial discrimination, but there's a different reason for it. It's because there's a political process there where this is a nation, and nations have authority and power. It's a collective power over that, and that should be the discussion. But the Supreme Court doesn't recognize that second part of that equation. So I'm really concerned that when one of these cases make it up, and there's a couple other ways that they're trying to get it, it's being led by the Christian nationalist movement, which is really pushing this. And they're the ones behind Trump and everything. It's a 40-year, they're the ones that was behind the abortion issue. It's the same people, same law firms, the exact same law firms are representing the white people against Indian people and the same thing that represented the abortion people and so forth in the adoption. And so these cases, when they come up, if they get one decision that says that that it's discriminatory to give Indians is a race, to give Indians special treatment and discriminate against white people, and it's forbidden by the U.S. Constitution. And that runs the risk of throwing out all tribal sovereignty, extermination by law overnight, because you can't, no education benefits, no 638 contracts, nothing. You don't get anything if you're, just because you're Indian. But anyway, so that's the scariness, and people aren't talking about that. Yeah. Yeah.
So the only way to combat something like that is becoming what you are, an attorney.
You have to
people educated, right?
Yeah, and that's what they tried to say in this. They said it's not an Indian discussion, it's a discussion of national rights, native national rights, and you're sovereign. You can't take the children of Mexico. You know, and they can say, well, you can't take us because we're Hispanic or brown. You know, you can't take them because they're a separate nation. That's why you can't take them. And they tried to make this argument, the U.S. Supreme Court ignored it. All the courts have ignored those arguments. And so in order to do this, and there's a great quote here by Alex de Tocqueville from, when was it, about 1836, I think, or whatever. They were moving the Cherokees down to Oklahoma. Half of them died on the way. Volunteers. He witnessed this. And he put in this quote here, well, the Spaniards, the way that they deal with Indian people, they just lined them up and shot them and killed them. But the English, the Americans, were so much more civilized. They did it by law. Genocide by law. And there's a wonderful quote here. It says, they did it without shedding blood and without violating a single great principle of morality in the eyes of the world. It is impossible to destroy men with more respect for the laws of humanity than the United States have done. I mean, and this was 100 years ago that he made that observation. So it's called, actually there's a term for this. It's called lawfare. Some of you may have run into this. It's a new term. It's gotten kind of popular. Let's see if I got it here. Yeah, there we go. It's a new term that's being discussed a lot, and it's used to describe a situation where the courts are being used as a weapon of war. And you actually there's a nice quote that I like to see from Dean Patel, who's one of the father of the law of nations, international law. One thing he says is that an occupied people, as long as they resist, as long as they don't accept the occupation, are in a state of perpetual war. And he says you don't have to have guns, you just have to resist. So you have this war going on in the courts. It's an actual war going on in the courts between colonized people and their colonizer. And that's called lawfare. Now, normally they talk about lawfare being used by the people in power against other people, right? So the new Jim Crow, the drug laws being used against black people to keep them down. You know, that's lawfare, right? Well, what I found as a movement lawyer, what you can do, you can take the weapons, the power, the weapons. You know the law. You learn the law. You're arming yourself and your people that you represent. You can turn them on the other side and turn it. When the warriors came back from Vietnam, warriors of color came back from Vietnam, they were all trained in the use of weapons and explosives and tactics. Who did they become? They became the Black Panthers, the American Indian movement, and so forth. So these weapons of war were actually turned against the system to fight back. And you can do that in the legal system as well. So you'll see that. So if you're going to think outside the colonial box, and I better watch my time on this, they give me an hour, right? I know I'm going to run by. Okay. So when you think outside the box, what are you going to do? You've exhausted all your domestic remedies, the remedies of your nation, so-called nation, right? Supreme Court, high colonial court. So you got to think outside the box. Native people didn't start doing this until about 1970 or 80. In that, being led primarily by the American Indian movement when they created the International Indian Treaty Council, which led the process that ended up with the UN Declaration of Rights of Indigenous People. That was all started by militants from the 1960s and 70s, militant Native people, and they realized that you can't go to you're not going to succeed in a colonial court. You got to get outside a colonial court. Now, the interesting thing about, and these are the different places you can go. There's a special committee on decolonization, which comes directly out of the UN Charter. If you read the UN Charter, the last quarter of it talks about decolonization. It talks about you. You know, but very few people pay attention to that. Puerto Rico is before this UN Special Committee on Decolonization, right? And because the last quarter of the charter says we have to decolonize, it condemns colonization. It says we got to end it, and it sets a whole process. It's so important that it's actually in the charter. And they set up this committee to deal with decolonization. What are Native people talking about today? Decolonization. So you can go before the UN Human Rights Council with a petition. You can go to the committee. They have what's called a UN Committee on the Elimination of Racial Discrimination, which comes out of a treaty on racial discrimination, right? They enforce that treaty. The United States has signed and ratified that treaty. The Western Shoshone used that treaty to find that federal Indian law is violative of human rights of Native people. And you can go before the Organization of American States, which is where the Onondagas are, where we are now. The United States is a member of the OAS, right? And their body is the Inter-American Commission on Human Rights. They have a court and a commission. To go before the court, you have to ratify the American Declaration of Human Rights. The United States has refused to ratify that. So you only get to go before the commission. But as long as the commission's set up under the OAS charter, so if you're going to be a member of the OAS, you have to subject yourself to the commission. So you can sue the United States and they have to appear. They can't say, well, we're going to ignore you. They can ignore you to their peril. But you get to, and then you'll get an answer. So that's what we did. So what are you looking at? So you're not looking at domestic colonial law. You're not looking at federal Indian law. You're not looking at the U.S. Constitution, civil rights, right? By the way, the Indian people don't come under the U.S. Constitution. Indian nations do not have constitutional rights, right? Where do Indian nations get their rights from? They get it from Congress. Congress passed the Indian Civil Rights Act because they don't come under the U.S. Constitution. So if you read the Indian Civil Rights Act and you compare it with the Bill of Rights, not all the rights are there. Native people don't have the same rights even today, Indian nations, under the U.S. That's because they were never citizens of the United States. Right? I believe that Indian Citizenship Act is unconstitutional because it's the Constitution that defines citizenship, not an act of Congress. Right? So I think it's unconstitutional. And if they want to make Indian citizens, then it has to be done through a treaty. Through a treaty. That's why nation to nations talk through treaties, right? They don't talk through an act of Congress. You don't sign an agreement with the government. You sign a treaty. So anyway, so there's a couple here that are important. The Universal Declaration of Human Rights have several that involve Native people. And here's the UN Charter we're talking about. I use this one all the time. Remember back in 1613, Equality of Nations? You'll see it in the UN Charter. All peoples and nations, large and small, are equal. All peoples and nations. Peoples mean they're not even nations yet, they're peoples. Peoples means you have an identity that creates the right of sovereignty. So you can be a group of people that have not formed a centralized government, but you have a right to do that. It's called right of self-determination. And that's a human right, collective human right under international law. So you have land, you have a population, you have a common ethnic or a historical background, right? Then that makes you a peoples with that S. I put that S on the end of the sovereignty. And then you can become a nation. Once you become a nation, then you have the body politic that you have to participate internationally to make treaties. So that's what that's all about. And that's interesting thing about the United Nations is it's supposed to be a group set up of nations. It's not a group set up of nations. It's a group set up of states. States are a political entity. Nations are an organic entity that come from the people. It's a very big difference. So it's kind of crazy that you can be a state. A state can be a member of the UN, but a nation cannot be a member of the UN, even though it's called a United Nations. And that's part of the work I'm doing right now with some other people is trying to change that. There's actually a term for nations. It's called the Fourth World. Google that sometimes, the Fourth World. Those are the native nations, right, that have never been decolonized. We had decolonization after the Second World War. It did not involve native people, right? So you just traded one colonizer for another, right? People here traded Great Britain, France, the Dutch, and the Spanish, and the French for the United States. So I call them successor colonizers. And you'll see that here. So this is 1794. He said the same thing. This is 100 and almost 200 years later, after the Dutch said we are a free and independent people. And that's when they signed that treaty. So these are some of the rights of the Universal Declaration that impact Native people. And so this is where we've begun to look. The OAS Charter invokes human rights. Now, a lot of the ways the United States tried to get out of obeying their human rights obligations say, well, we never signed any human rights treaties. They refused to sign the treaty on women and children, for example, because they didn't want to be bound by that. They won't sign the treaty on economic human rights because of capitalism. So they avoid these human rights treaties. But this way you can bootstrap them, and we find this in these decisions now coming down from the Commission. Is it says you have to respect the rights of the individual, and then with this they have what's called the rights and duties of man, which is the Universal Declaration for the Americas, right? And the U.S. has said it's not a treaty, it's not binding, but what they do, what the Commission says, this is what defines the rights declared in the Charter. And if you're bound by the Charter, then you're bound by this. And so, and one of the interesting things about this declaration, by the way, that was been used in Indian cases, was used in the Western Shoshone case, and in a number of other cases. They say that spiritual fulfillment is the highest aspiration of man. That's in there, in this document. Spiritual fulfillment is the highest declaration of man. Well, what does that have to do with Native people? Native people are spiritual people. First and foremost, Native people, they're called chthonic because they come from the earth. They're defined by the relationship with the earth. They're a spiritual people. So when the Commission saw this and they looked at that language, they applied it to Native people. And they said that the colonial domination violates the spirituality of Native people when they take their land from them, because they have their spiritual connection to the land. Think about that. White people don't have that spirit. You can put your church anywhere. Native people can't move their church because of that spiritual relationship directly with the land. That says that in these cases, and they followed it. So it's an amazing concept here on this one. So Inter-American Commission on Human Rights is what we've gone before. And then they do have the American Convention. And again, what has happened is when they talk about rights in the Charter, what the Commission has been doing is say, well, we're going to look to see where they define human rights. If you got a right to property, where's that defined? So even though the United States has not signed this, right to property, right to self-determination, right to equality, whatever, all these rights are in there. Even though the United States didn't sign this, the Commission says, well, we're going to look to this for guidance. So when we define what is property for Native people, are we looking at Western European fee simple title? Or are we looking at communal spiritual relationship title? And they use this to look at the Indian definition title, the Native definition title. They don't look at the what we call Wasichu or white definition title. So, and one of the big cases they did this in was in 2002, the Dann case. Mary and Carrie Dann were sheep herders, two Western Shoshone sheep herders, and their treaty lands had been made into a national forest. So they would cut down the fence and herd their sheep onto the national forest to graze. And they got picked up, so they had a running battle with the national forest because they said these are treaty lands. And eventually made it all the way up to U.S. Supreme Court. The U.S. Supreme Court said, no, they were taken from you. They said no. So they finally, same thing happened with them as with the Onondagas. So then they filed this petition before the Commission, and after 10, 15 years of litigation, they won. It's the first case like this. And they declared in this case that federal Indian law, the law of the United States, violates the human rights of Native people to equality, right? To an effective remedy because they can't get their land back, and to property because it didn't recognize the native tenure, the native property concept. And so it violated that right. There's another case in Australia called the Mabo case, where they did the highest Supreme Court of Australia did the same thing. But this is the first and only case until our case in 2002. So then we filed for the Onondagas using some of the same arguments. That's Joe Heath down there. He's the lead counsel for the Onondagas. He lives near Syracuse. And So we asserted 3 rights: equality, essentially right to a fair trial and effective remedy. These are human rights, and the right to property. And that article there is the article within the American Declaration of Rights and Duties of Man that I just mentioned. So it's like, and so we, after 10 years of litigation, right, we finally get a decision here in 2023 admitting our case. Now, there's a two-step process for these cases. The first one, they look at what you filed and they said, we call it a motion to dismiss here in the United States. There, they call it a motion for admissibility. They look at your case to say, if you prove everything you say in your complaint on the facts, do you state a claim for a human rights violation? And they said, yes, we do. So we alleged all those things I talked about for the Onondagas, the theft of their land. They looked at those facts. The United States did not fight on the facts. They tried to get it thrown out because they said it was too old, right? That was their only defense, the equity defense. Equity, same thing. They won before the U.S. Supreme Court. Why not here? They threw it out in international law. There's no equity defense for the theft of a nation's property. There's no statute of limitations for the theft of a nation's property. Right? So, we won on at least 2 of those issues. We're trying to get them to rehear the property, but anyway, that's a decision. So after the second step then is they do what's called a merits hearing. That's like summary judgment here, where you present your evidence and you try to prove your case, and then they look at the facts, and then they go ahead and issue. If you win at the admissibility level, you've already had a legal decision as a matter of law. It's a violation of human rights. So all you have to do is prove out your facts. Government never disputed our facts. So we filed this merits brief. It's 100 pages long, 74 pages long, with 200 pages of evidence or whatever. And the government didn't even respond, didn't dispute it. This was a year ago. We're still waiting for a decision. It takes them a while, could be a year or 2 before we get a decision. But it's very likely, I think, that we'll get one in our favor. But, and if we do, this is the first time that a Native nation has sued the United States in a human rights body like this to have it declared unconstitutional. The other big thing about this, our approach on this, is that we're challenging the United States just not on human rights. We're saying all of these human rights violations come from one source, and that source is colonial domination. Colonial, that Native nations are occupied nations, occupied by an empire, and they still exist as a nation. So we're getting away from that race concept and individual rights concept. And the United States is an empire, right? And it won't call itself because it doesn't want to be held accountable for being a colonial empire. And so colonial decision is defined by control of a dominant nation over a lesser nation. And, here. So federal Indian law is the domestic law of colonialism. And you'll see that in all your books. So when you go to law school, this is what you study. Right? There's no discussion about it, about federal Indian law being colonial law. They don't discuss international law in your law books, even though it's a matter of international law. So the law, doctrine of discovery, because these are all colonial doctrines, and native incompetence and so forth. They become, and the other thing about colonialism, and this is also being developed right now. One of the reasons why there's no statute of limitations. Why is there no statute of limitations? Because as long as you're colonized, every single second is a new violation. If somebody takes your car, you're suffering the loss of your car until it's returned. It doesn't matter whether they keep it 10 minutes or 10 years, right? It's a continuing, what we call in the tort law, continuing tort. Your property's been contaminated. It's contaminated every single day. It's been contaminated. That lake, Onondaga Lake, is continuing. The fact that they can't go and practice their ceremony, can't gather, can't use their land, that's a continuing violation, right? So Peter Wolf, not Peter Wolf, forgot his name, is Professor Wolf, came up with this concept that colonization is a structure. It's not an event. It didn't just, colonization didn't happen in 1492. It's ongoing. It's a structure. So if it's a structure, what does that mean? It's institutionalized. So you get indoctrinated, right? That's part of the institutionalization of the colonization, is you indoctrinate the lawyers, right? That's why you got to kill them. And so you go to law schools, you send Indian people. Remember when they kidnapped that kid, Columbus, kidnapped the chief's son and sent him away? We do that with Indian people when you send them to Native people, when you send them to law school. They were kidnapping Native people, sending them to colonial law schools to teach them colonial law so they can go back in their communities and work as agents of the federal government to destroy their own people through forced assimilation over a long period of time. And poverty, imposed poverty. And so it's a conflict of interest. You have to swear, every single Native lawyer has to swear their oath of allegiance to the U.S. Constitution. And Native people aren't even in the U.S. Constitution. There's two places, Indian Commerce Clause and that they shall not be taxed. So it's a matter of international law. There's four international, we're now in the fourth decade, calling for the immediate elimination globally. They call it eradication of colonialism. This is the UN. The World Congress calling for the immediate elimination of all forms and manifestations. Think about that. All forms and manifestations of colonialism. Federal Indian law is a manifestation of colonialism existing today. The relationship between Native people in this country and the United States is a manifestation of colonialism. Under the World Congress, it's called for its elimination for 4 decades. This right after during that period of decolonization, this is the first one called UN Resolution 1540, calling for the recognizing the right of self-determination and all Native indigenous peoples, calling for immediate decolonization. Done, and the decolonization should be funded and assisted by the colonial power. So it created an obligation on the colonial state. Native people shouldn't have to just free themselves. The dominator has a responsibility to restore people. This is the right of reparations, the right of restorative justice, and so forth. That's actually in this resolution passed by the UN, by the World Congress here. And these are some of the other ones that have happened during that time. So federal Indian law is also racist. I discussed that earlier. So it's got two hats. You've got a political hat, which is the nation hat, and then you've got a racist hat, which is the Indian hat. Indian is a colonial word. American Indian is a double colonization, right? Native American, you're not Americans. Native American is a racist term, colonization, so forth. It's called crime of apartheid. When you create two sets of laws based on race or ethnicity, it's called apartheid. That's what they're doing in Palestine. Palestine is a situation of apartheid. They're doing it here, and it's apartheid law. Yeah, it's also genocide. I've got a article coming out discussing federal Indian law as a manifestation of genocide, right? And this definition of genocide, the intentional destruction in whole or part of a national group, a nation, ethnic group, ethnocide, culturecide, linguicide, racial group, right? Racism, or religious group, religicide. So, and it's systematic, right? Systemic. So, racism and settler colonialism go together. And you'll see that here in this one. This is probably the most important document for Native people that's not paid attention to. It's called the International Convention on the Elimination of All Forms of Racial Discrimination, right? And in here, in the preamble, they adopt this decolonization resolution I just mentioned, calling for the immediate eradication of colonialism around the world, 1514. And recall that the United States has both signed and ratified this. I think it was signed by Carter in the 1970s, and it was ratified by, I'm out of time. It was ratified by Bill Clinton. I mean, the Congressman Bill Clinton was there. So you would use the Vienna Convention on Treaties. We have the UN Declaration, right? And all the UN Declaration does, it doesn't create rights. What the UN Declaration says is that Native people have equal rights, have rights equal to all other peoples. So these rights already existed for everybody else. But all the UN Declaration did was to give these rights, recognize that these rights actually belong to Native people. So these are some of the rights that everybody else had that weren't recognized for Native people until 2007, right? And so in international law, we do a shaming. You shame people to make them, you shame the United States by exposing its colonial rule. You go through restorative justice. There's a process here of decolonization that's actually recognized in the UN. So I'll get there here on this one here. This is a UN resolution that actually defines how you decolonize. It's a cookbook, how you get restorative justice. You're going to go talk about reparations, whether it's for the African diaspora or for Native people. This shows you exactly right to the truth and apologies, truth and reconciliation commissions, reparations, return of land. All of that is in here. There's actually a cookbook. Very few people actually talk about it. So that includes the land back and those kinds of issues. So anyway, thank you, Mitakuyasin, which means all my relations, in Lakota, and Mopalau, which is thank you. Appreciate it. So I kept you over just a little bit. Before people wander in, if you have some questions you want to sit, I'll say here. Yeah.
Now, I appreciate the presentation. What I say might sound like giving up perhaps, and that will never be the case, but some of the slides in your presentation, United Nations and other efforts that tribes may take on or indigenous peoples may take on, courts or forums or whatever. The United States, as negative as it can be about this country, it will never relinquish its authority or give in to these other forums where folks can try and uphold or fight for their rights, indigenous rights. Not saying that you don't use every form available, but regret by definition implies conscience. This country doesn't have a conscience. This country doesn't have any regret. This country is getting worse with this current administration. That's called politics, but we're going backwards. We're back to the 1960s and the civil rights issue. So, as much as you gotta have that hope and that energy and never let the young ones down, because you gotta keep fighting for what we have, because our ancestors fought for it. And they paid a higher price because they died for it. We're fighting in courts and whatever, but it's good to hear these things, but still, it's like, even if I hope every case that has indigenous rights being fought for, they win. But in the end, what's the result? What's going to be given? Land will never be given back. Maybe there's a few dollars, but the Black Hills, as you mentioned, and the tribe never took the money and never wanted the money. They want the land back. But will they ever get it back? But still, you have to keep fighting. You have to never. You can never give up, because damn, our people, our grandmas and grandpas, whatever, they pay too high a price. So for our next 7 generations, we sit in these rooms and we discuss and we strategize and whatever. But still, we're fighting the supposed best country in this world, but yet look what it did to its indigenous peoples. And still to this day, it was one of the screens was a slow genocide. I don't know if slow is a good word there. It's a continuous genocide. It may have been quicker back in the when they came across the ocean. When they destroyed within 200 years, they brought about the demise of 90% of the indigenous peoples. 90% of the indigenous people were gone within 200 years of one of them people coming across the ocean. 90%. And still to this day, there's only, 3.5 million Native Americans that term. What used to be 100 plus, whatever amount of people. But still, you can't give up and never ever. But what is it going to be? Is there a result that's going to be positive for the Native people? And I like how you put that. It's a double colonialized or whatever, genocide. Native American. Bottom line is, I appreciate the presentation, but much hope, much giving up that you don't get into. What's the result?
Yeah. Let me say something real quick, and it also addresses your question earlier. This is a toolbox, right? This is the ultimate, but for each Native community will have to make their own decision about how they want to deal with this. Some Native communities are okay just being an ethnic minority, right? But some want to be a member of the UN, right? But that's a decision. It's a continuum on there, and you have to decide where along that. Some are okay being an autonomous region. None of that up in Canada. these reservations are autonomous regions. They have their own self-governance and that kind of thing. So they're much better off than some of the communities in Australia, for example, where they're just trying to get their boundaries. We're much better off than most indigenous peoples in Africa, for example. But you're right, and I didn't mean to say this is the only route, because you're involved in a survival. And for your survivals, you may have to raise some of these federal Indian law doctrines saying the United States has a trust responsibility. I'm going to admit that exists, even though I don't agree that I'm a savage, incompetent savage, but they do have that responsibility, so I'm going to take advantage of it. So you do make those arguments. So you can use federal Indian law, but keeping the larger picture involved. What I do as a lawyer is I go in and I make those Indian law arguments, but I put them in the context of a colonial domination. So I'm saying, so I say, you have assumed plenary authority over me. I don't agree to your absolute authority over me, but you have assumed that, right? So that's the way I always say assume plenary power. I don't say the United States has plenary power. And you'll see Indian lawyers go into court saying the United States had plenary power over me. They don't. They assume that they have plenary power. They have de facto, but not legal, de jure. But yeah, yes. Go ahead.
I have two questions. First one is, do you know if any of the New York tribes have been able to use Wicker to repudiate the city of Charlottesville? That's my first question. And then my second question is, the Second Circuit's been using latches against Holocaust victims in looted art cases. Is there any precedent, which is kind of newly developed, but is there any precedent in the international arena that tribes might be able to use a similar argument to try to get around the Second Circuit latches against Holocaust victims? Because I see a lot of similarities between that international realm with the land cases.
Yeah, international law doesn't really recognize latches, so that's a place you can go. Also, in the Oneida decision, they didn't really use latches; they used equity, and it's because latches there's no statute of limitations for some of these violations. So if there's no statute of limitations, like there's no statute of limitations for murder for a lot of times, So there's some crimes that are so bad. So you don't have latches so much as you do have an equity that they use, but even that should not be applied. There are some things that have been written after that decision that said within international law there's no concept of equity in that sense when you're talking about these severe human rights violations. You can't get away just by time, and we know this because some of the people that committed the crimes in the Second World War, they were captured 50, 60 years later over in Argentina or someplace and still brought over in crime, so that should be. In terms of whether McGurk can be used, the interesting thing about McGurk, even though the U.S. Supreme Court recognized the Creek Nation territory had not been expressly taken by Congress, then they went ahead and said that Cheyenne and Arapaho had, and a couple of other reservations, they just dissolved them overnight. They said they don't exist. And that was the Oklahoma Criminal Court of Appeals that said that. Because the Indian people were saying, yeah, I'm on Indian lands and the state doesn't have jurisdiction over me to try me. That's how the McGurk case got up there. And what they said, yeah, well, we looked at how they're taking and we said that you lost your land. So now they have to go back and fight to say that they exist. So McGurk is a mixed bag. I guess you can make the argument that if there never was an expressed act of Congress, like the Onondagas never had Congress saying that they took their land. It was just illegal takings by the state. They can make the argument that their full territory, the full amount of their land, those dotted lines still exist. So that's an argument you can make. Whether the Supreme Court would buy that, I don't know.
So my husband is from Syracuse.
From where?
Syracuse.
Okay.
Drive up there.
Right.
And we drive up from the highway, that land that's there. We see teepees on the land, and we see that lake. Or
Right.
talk about that earlier. Is that land being fought for now?
Yeah, it is. They've asked for that back, but they want it cleaned up. It's being fought for right now. The tribe has.
So is it still in a court?
It's more. At some point, you reach a point where you've exhausted all your legal remedies. You can't do really much else. Then it becomes a political question. And that my last slide, one of the last ones, I had this concept of shaming. Once you have the United States declared as a human rights violator, then as your group, you can go back and you put that in all your literature. You shame the United States. And by shaming them, hopefully you can get them to the table to start talking. They may not give you back 2 million acres, but they might give you back 100,000. You know, which they wouldn't give you if you weren't able to shame them. So that's the advantage of most. The United States really doesn't recognize international law. So that's the advantage of doing that. They're shamed at Guantanamo if you hold torture as being a human rights violation. They're shamed in terms of Gaza right now because you're showing that the bombs come from the United States. Therefore, we're complicit in genocide. So that's a whole shaming process. So there are acts of Congress now trying to stop the weapons from going over to Israel to stop the bombing. And so they use the shaming. So there's a value in that. And that's it. We actually use that term in international law.
And people have to be willing to want to be shamed.
Yeah. Yeah. You have to be what?
Be willing to want to be shamed to get into the country.
Well, we do it whether they want to be shamed or not. You know?
Yeah. And another question was the woman who lost the children.
Right.
Talking about that being in the 70s. It's not
Right.
still happening.
The children are still gone. Yeah.
But it's the case still alive. You never said it.
She's still alive. Yeah. The case is still alive. Yeah. They never made a decision. Still pending in the court, in the commission. So we got to get out of here. There's maybe one more question. Did you have one?
Yeah. On the executive order from DEI and also from a lot of the, I guess, agencies saying that DEI has treated responsibility. A lot of your slides bring up the racism aspect of it. And right now, in order to come under DEI, federally recognized tribes are saying that doesn't apply at all. It's just treat your responsibility, forget diversity, equity, and inclusion.
Well, that executive order is being applied to the institutions that manage native funds, like the BIA and the Department of the Interior. So, in fact, they had pulled down. I know in one of the museums they pulled down some Indian stuff. I think the code talkers during the Second World War, the Navajo code talkers, they pulled that out of the museum as part of DEI. So it'll go on. So they don't.
They didn't put it back.
Yeah.
More interesting.
But they're not going to teach the shameful history of genocide by this country of Native people. You know, anymore they're going to teach the diaspora for slaves. Thank you very much for coming.